Tonight on the Daily Debrief, in California, a former NFL player is accused of sex crimes against 5 women.
I kept on saying, ow, 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 because I don't know how he fit that thing in there.
The first accusers take the stand, but are they credible? Also in Vermont, a verdict in a wrong-way highway crash which killed 5 teens. Did the insanity defense work? Plus, a man who killed his 5 kids couldn't help but confess to pretty much everyone.
When that door closed, I guess reality kicked in to where he knew he was in prison.
Now he's also claiming insanity. Real-life cases are happening nationwide. This is the Daily Debrief for Wednesday, May 22nd.
Good afternoon, everybody. Aaron Keller here, along with Julie Rendham and Michael Bryant. Attorney Ann Bremner will join us in a moment. We begin tonight in California with day 3 of the trial of an NFL player accused of sex crimes with 5 women ranging in ages from 17 to 77. Kellen Winslow II played 10 seasons with the Cleveland Browns. He faces the charges on your screen, some in multiple counts. The maximum penalty, if convicted, is life with the chance for parole. A sex assault detective testified that he started to make links between similar reports of sex assaults. So he scheduled follow-up interviews, which led to the recovery of physical evidence.
Was there a point in time where you met personally with Jane Doe 1?
Yes.
Did you also meet with her on a second occasion on June 12th of 2018?
Yes.
When you met with Jane Doe number 1 on June 12th of 2018, did you ask her whether or not she had retained the clothing that she had worn on March 17th, 2018, the day that she stated she had been assaulted?
Yes.
Did she tell you she had?
Yes.
Did you, in fact, retrieve and recover the clothing that she had been wearing that day?
Yes.
What items of clothing did you recover?
Pants and underwear.
Can you describe the pants that she provided you?
It was a white leather pants, and the underwear was the women's underwear, pink in color.
In terms of the pants, can you describe the condition of them?
It was white, leathery, and I saw some stains on the pants. I separate each item and package them separately, seal them, and I then submit it into our main evidence for processing.
So, do the clothes contain key evidence? Here is the cross-examination.
Occurred on March 17th, is that right?
Correct.
And you received these items on June 12th, is that right?
Yes.
So about 3 months after.
Yes.
Isn't it important to get items right after the event? Is that important?
That's correct.
Yeah. And that way the evidence is fresh, right?
Yes.
She saved her clothes for 3 months, is that right?
Correct.
Did she wash them?
Yes.
Objection calls for hearsay.
Sustained. The answer will be stricken. The last answer will be stricken from the record. The jury shall disregard it, just treat it as though you never heard it. All right, next question.
Did the pants appear clean to you?
I'm sorry?
Did the pants appear clean to you?
Somewhat. There were some stains on it.
Did they appear like they had been washed?
It's hard to tell with the stains.
Okay. These items are usually gathered during a SART exam, is that right?
Correct.
Okay. What is a SART exam?
It's offered to victims of sexual assault where they are examined by a forensic nurse, so they can transfer to a facility. They are interviewed by a forensic nurse and, again, physically examined where they collect DNA evidence, take photographs, etc.
So those are very important exams, is that right?
Correct.
Those exams can be used to prove a violent rape happened, right?
Yes.
Did she, in fact, do a SART exam?
No.
The first accuser, the so-called Jane Doe number 1, testified for several hours. Here is her graphic testimony.
When he got on top of you, did he feel heavy?
Yes.
Did he hold you down in any way?
Well, when he inserted his penis, it hurt so bad, I don't know how I could have even opened up. Because
So, Ms. Doe, let me ask you.
okay.
Let me ask you a question. Did it hurt when he penetrated you vaginally with his penis?
Yes, I kept on saying, ow, ow, ow. don't know how he fit that thing in there.
Did he push upon you, or did he just push his body against you?
He had his body against me, but he had his hand like on my back. Like,
Now,
Well, you're indicating on the right side of your back, is that correct? Where he had his hand?
yeah, he had his hand like, let's see. Yeah, he had one of his hands on my back. That's all I remember.
Okay, now you're indicating on the left side. All right, next question.
and when you say that he had his hand on your back, was he basically mounting you in the front passenger seat of the vehicle? He was on top of you.
Right, he was on top of me.
Was he able to penetrate you vaginally, though?
Yes, it felt like a bunch of water or something came out. So, like he went in for like a few minutes. I don't even think it was even more than 5 minutes, not even that. And I just felt this heavy gush of water going.
What did you think it was?
Blood.
when you felt
It was
that?
blood.
On cross-examination, the defense picked apart the accuser's past misidentification of the defendant's attorney as her attacker.
You came to court, you testified before the lawyers and the judge, right? Remember that?
Yes.
Okay. And you remember, you pointed out this man
Right.
being the individual who raped you. Remember that?
Yes.
Okay. This man I'm standing in front of.
Yes.
For the record, this is Mr. Watkins.
The record will so reflect.
And that's still the person who raped you?
No, it's the one next to you. Him.
In the prelim, you were pretty sure about
Okay,
it, right?
just a moment for the record. The person next to Mr. Watkins is the defendant. Next question.
But in the prelim, you were pretty sure it was Mr. Watkins. Remember that?
Yes, I did say that.
And here the accuser misidentified the type of vehicle she said her attacker was riding in.
People who picked you up?
Yes.
Okay. So not the Jeep.
I think, yeah, I'm almost positive it was a truck
Okay.
like that.
So now you're positive that this is the vehicle, right?
Right.
So in other words, before, you were fairly positive it was a Jeep because you read J-E-E-P. Do you remember that? You told the police
Yes.
that. And you were positive that it was a two-door. Do you remember that? Because you told that to the police.
Right.
And you were also positive that there were no back seats because you told that to the police also. You remember that?
Yes, then it must have been a Jeep. You're right. If I said that, it must have been a Jeep.
So then this isn't the vehicle because this
Now,
is not a
that's a
Jeep.
Hummer. It was nice, but it was a Jeep. You know, it's been a while.
So in your well, you tested that's the.
I know. I was thinking that, but it's not that car.
The second accuser, the so-called Jane Doe number 2, took the stand not too long ago.
He held me, grabbed my arms, and I don't know what else he said, but he says we're gonna have sex. And I said, please don't do this. And I said it about 4 times, and something like, it's a done deal, and
Ms. Doe, let me ask you about that. So when you say that you said, please don't do this, you think you said that about 4 times?
mm-hmm.
Is that a yes?
Yes.
And when you say they were held, you're clasping your hands together, did he actually place his hands on your forearms and hold your arms together?
He held my hands together, yeah.
Tell us what he actually did on the side of the car when you were in the passenger seat.
Well, he had me take my pants off and pulled me on front of the seat and started to, and
So Ms. Doe, I have to ask you, when you say that he started to, what did he actually do?
Started to rape me.
Joining me on the debrief are attorneys Julie Rendelman, Ann Bremner, and Michael Bryant. So, Ann, let me start with you. The point of a jury trial is to try to determine the truth here. We've got, as to Jane Doe number 1, misidentifications as to the car, the attorney, the defendant. So is this accuser, Jane Doe number 1, telling the truth?
a downhill start, right, for the prosecution right now with misidentifying the defendant and everything else. But on credibility, a jury can still find her to be credible. In terms of whether or not she's accurate may be a different story. Does she recognize the defendant versus describing him? She picked out his attorney, but they have to look at prior identification procedures as well, and also her certainty versus accuracy.
Julie Rendelman, your thoughts?
I think one of the things that we didn't see here was some of the cross-examination involved areas where she was clearly not being credible to the jury, and that was in regards, if I remember correctly, talking about her alcoholism, because I believe he was asking questions to her about that. She said she hadn't done it in years. It turned out she had been arrested for public intoxication, I think like 5 or 7 times recently. So those things, while small, are the things that you can use with the jury to say, you have to prove it beyond a reasonable doubt, and that lie allows you to believe that she's not telling the truth about everything.
At one point during cross-examination last evening when I was here, she admitted that she said the phrase, "bring it on," to the defendant. Now, could that be construed as some sort of, acceptance that it's, in other words, it's not rape, it's consensual? Michael Bryant.
Well, I think what helped this victim 1 best was victim 2, because there were so many consistencies in the location and the manner. Because victim 1 was like, hey, whatever you need to do, let's just get it done and move on. If you're going to rape me, let's do it and get it out of the way. But the way she handled it was so different than victim 2. It's the consistencies between the 2 victims that helped support victim 1, not her manner.
And that's the key when the prosecution brings all these different elements into a trial together. The individual accusers, alleged victims, can bolster one another's testimony. We will wait for this case to resume here on the network. Sentencing, meanwhile, has been delayed in the case of the bachelor's Prince Farming. Chris Soules of Iowa avoided a trial by pleading guilty to leaving the scene of a deadly crash. The defense argued that the family of the victim should not be allowed to give statements, and the judge agreed because Soules did not plead guilty to causing the crash or the death. The defense also asked for a pre-sentence investigation to be rewritten because it was not narrowly focused on the single charge to which Soules pleaded guilty. The crash killed 66-year-old Kenny Mosher of Aurora, Iowa. He was on a tractor when Soules hit him. Mosher was a Vietnam veteran and lifelong farmer. Court records say Soules settled civilly with the family of the victim for $2.5 million. Still ahead on the Daily Debrief, a jury deliberating in the insanity murder case of a Vermont man accused of a wrong-way crash on the interstate. They have come down with a verdict. We'll let you know where that stands. Plus, a corrections officer provides yet another account of a chilling confession from the man who admits he killed his 5 children. We head back to the courthouses after the break. A verdict to report in the case of horror on the highway. Stephen Bourgoin of Vermont faced 5 counts of second-degree murder and other lesser charges. He argued that he should be found not guilty because he was legally insane. Authorities believe this is how it probably looked, as Bourgoin sped down the wrong lane of a Vermont interstate highway, swerved to the left, and slammed head-on into a vehicle which was traveling in the correct direction. The occupants of that other vehicle all died at ages 15 and 16, but the defendant survived to steal a responding police car, take off down the highway, turn around, and then ram into the wreckage of the first crash at 103 miles per hour. Here is the verdict.
Count 1, with respect to the second-degree murder involving Mary Harris, how did the jury find?
Found him guilty.
Of second-degree murder?
Second-degree murder.
And that was unanimous?
It was.
With respect to the affirmative defense of insanity, did the jury conclude that the defendant had failed to meet his burden of proof with regard to insanity?
Yes.
And was that decision unanimous?
Yes.
So say you all?
Yes.
The charge involving the second-degree murder of Cyrus Shao, how did the jury find?
We found it charged guilty of second-degree murder.
Was that verdict unanimous?
Yes.
With regard to count 3, the second-degree murder involving Liam Hale, how did the jury find?
Found Mr. Bourgoin guilty of second-degree murder.
With regard to count 4, the second-degree murder involving Janie Kazi, how did the jury find?
We
found Mr. Bourgoin guilty of second-degree murder.
With regard to count 5, the second-degree murder of Eli Brookins, how did the jury find?
Found Mr. Bourgoin guilty of second-degree murder.
And was that verdict unanimous?
Yes.
With regard to count 1, the gross negligent operation of a motor vehicle, how did you find?
We found Mr. Bourgoin guilty of grossly negligent operation of a vehicle.
And with regard to count 2, the aggravated operation of a vehicle without the owner's consent, how did the jury find?
We found Steve Bourgoin guilty.
The insanity defense did not work in that case. Sentencing could range anywhere from 20 years to a life sentence. The state has rested, and the defense now has the case of a South Carolina man accused of murdering his 5 kids. Timothy Jones Jr. could be executed if jurors find him guilty and eligible. He admits taking the lives of the children ages 1 through 8 and then driving around with their bodies in the back of his SUV for more than a week. Jones is arguing insanity. The mother of the 5 victims broke down while reading a letter she wrote to her dead daughter. This is the raw emotion.
My kids knew I loved them. Mira, my sweet, sweet daughter. I know that your heart feels heavy and that you feel really sad sometimes. I want to reassure you, sweetheart, that you, along with your brothers and sister, mean everything to me. You kids are my world, and Mommy and Daddy were very blessed to have you. God. Oh, God. I'm sorry. I'm sorry. My babies, my babies.
Corrections officer said the defendant was brought to him for safekeeping. The defendant told him what he did to his kids.
When he first came in, I explained to him the procedure that we got to do. We had to strip search. We had to do our normal strip search, fingerprint him, and then go to the medical station area. So as they brought him in, the 2 person, the sheriff department, whoever brought him in, they left the area, and when that door closed, I guess reality kicked in to where he knew he was in prison. Okay, he was explaining to me about how wrong what he did, how he felt sorry, and he was wrong for what he did. You want me to explain?
Yeah, go ahead.
Well, the incident that he explained to me that I recall was one of his sons, the youngest or the oldest, one of them's son was messing with the socket, and I guess he got angry because he could have killed himself or whatever, and to what he was saying that he grabbed his son and started strangling, choking him. And he said, I guess his hands was too big that he couldn't really put his hands around the neck real good, so he grabbed a belt, and he used the belt to start strangling his son. And the daughter, one of the daughters, I don't know if the oldest or the youngest, the daughter walked in, and I guess he saw the daughter, and then he grabbed her. And the thing that really got to me when he said he choked the daughter so hard to where she turned purple.
The defendant's internet activity included searches for mental health terms, plus this.
September 2nd, 10:35 in the morning, with a YouTube search. The string that was entered in the YouTube search was dog search for body in landfill. Followed up at 9:38 a.m. with another YouTube search for clean pool muriatic acid. And at 10:41, the YouTube search for muriatic acid burn. Followed by, at 10:43, a Google search for camping Columbia, South Carolina. At 10:46, there was a Google search. The key words that were entered were, what does no extradition laws mean? At 10:57, there was web history. The website was blogs.findlaw.com. The title page was 5 countries for no U.S. extradition treaty.
He wants to know if he can leave the country and not get caught, apparently. Attorneys Julie Rendelman, Michael Bryant, and Bremner are back once again. So, Ann Bremner, what do you make of these internet searches? Is this evidence that he really was trying to get away with this?
Oh, absolutely. Don't you remember in Casey Anthony with all the issue of the searches in that case? I mean, no extradition treaty, you know, with the United States and everything with respect to the camping and everything else. Oh my gosh, a jury looks at that and thinks premeditated. I mean, what else is he going to do? Why else is he looking at that?
I mean, is it possible that he was suffering from insanity and then became lucid and then he started looking for all of this?
Yeah, I mean, try that with a jury. Although I don't know in South Carolina. I mean, it's a whole different jurisdiction in terms of how they try cases, as we've just seen, and maybe how the juries find things. But that's a hard sell, in my opinion.
Julie Rendelman, we were just talking about the mother's testimony. She broke down on the stand. It's heartbreaking, but you had concerns about relevance.
Yeah, if I'm the defense attorney in this case, and we've seen this, we were talking about the Holly Bobo case, you know, I'm not sure how it's relevant for her to be reading a story that she wrote or you know, something that she wrote to her child in missing her. How does that get the ball moving as to whether or not this defendant is in fact guilty or not guilty of this crime? I don't understand it.
Michael Bryant.
Well, let me tell you, Counselor, I think what they were trying to say was that the relationship between the ex-wife, mother of the kids, and the defendant, the father, was so important that they needed to flesh that out. They needed this jury to understand exactly how she related to the kids and to the husband who ultimately took their lives.
So then let her testify to that. But why is she reading a letter?
I don't know. I think because the prosecution got away with it.
I think so too, and I think that I don't know if the defense objected or not, but if they didn't, they truly dropped the ball.
Yeah, this is going to be tough to unravel. Of course, you've got 3 layers of charges there. You have guilty, not guilty because of insanity, and then that middle ground, Michael Bryant, they could say guilty but mentally ill.
Yeah, I like that because it allows the jury to kind of compromise. Yeah, this guy's got issues, he's got problems. We're not going to excuse him for what he did, but we understand it. We're going to factor it into our decision.
And
we had
I don't.
testimony today from a mental health expert that he does have brain injuries and whatnot. So the defense has the case. We'll watch it roll along. Michael Bryant, Julie Rendelman, and Bremner, appreciate your insights on the debrief today. I'll be back here at 5 o'clock, 5:30 to watch testimony roll along in the Winslow case. I'll see you then.